again, welcome back to the Steve Fox Show, where it's you and the law, where you have the grand opportunity to call in and get some free legal advice. But tonight we have a very special guest. We have Her Honor Valerie Skeba, who's head of the Dependency Court here in Lancaster. If you have a question, feel free to call in at 726-0382, 726-0382. And before we went to break, we were discussing that there's more than one tract that people go on. The first tract is for reunification between the child or children and the parent. If that doesn't work, we put them on the other tract. Could you tell us about the other tract?
Well, the other track is basically finding a permanent home for the children. It can happen while the parent's getting reunification services. However, there are certain categories of parents that oftentimes the department does not wish to offer reunification services to. And those parents, severe physical abuse or sexual abuse of a child, parents who have had a number of children removed from them and they haven't reunified with, and sometimes parents who just will give up their child, they'll waive reunification services. Sometimes we can't locate parents, so those people would not be entitled to reunification services until we found them. So there's probably about, the other big one for a lot of people is somebody who's incarcerated beyond the length of reunification.
So what's the length of reunification? 6
well,
months?
It can be 6 months, it can be as long as 18 months. It depends on the child and what the parent is doing. But somebody who's incarcerated obviously is going to have more difficulty complying with the case plan.
Most low-grade felonies, the low term is 16 months, so that they can almost not make it then sometimes.
Well, usually, if that's the case, if they're only going to be in custody for 8 months, usually I will give them reunification services, and they will have, but when they get out, they have to begin immediately. And they're certainly going to be at a disadvantage because the child's been with usually foster parents, for 8 months, 24 hours a day, 7 days a week for 8 months, and they have a bond with this foster parent that the father or mother who's in state prison hasn't had a chance to develop. So they definitely are at a disadvantage, but we do try to at least give them an opportunity to establish a relationship. And I have had some parents who have been very diligent and have managed to do that. But it's not easy.
What percent end up having reunification terminated and go on the adoption track?
It's hard for me to say. I would guess probably, adoption probably less. It would be somewhere around a third. A lot of kids wind up with relatives who don't want to adopt. They want to go into legal guardianship or long-term foster care and give the parent another chance. So if you have a relative up here that you can place your child with, you are in better shape because oftentimes that relative is not going to try to adopt the child, and they will try to help with reunification.
Now, a lot of cases, you probably have seen everything. What do you see? What has been is there any trends you see going through our courts?
Well, probably the one I see the most of is substance abuse. And oftentimes there's a lot of domestic violence in the same case. So those are two things I see a lot of. We also have a lot of sexual abuse. And I'm not sure why that is, but apparently a study was done in the 1980s that found a very high rate of sexual abuse up here in the Antelope Valley. And I don't know why that is. I just know that we see a lot of it.
I've often wondered because if we report more, if there actually is more, to know we're spread out, so there's less opportunity for people to find out what's happening. But you were also an attorney in Monterey Park, so you saw a lot there too.
Not as much.
So you see a lot more up here is what you're saying?
Right, of sexual abuse, yes, significantly more.
And then when that's proven, then obviously the district attorney gets involved and possibly presses charges?
Usually not. I've had discussions with some of the people over the Juvenile Investigation Bureau, and they have told me that they reject they don't file. I think it's over half of the complaints. It's a pretty high number. The standard in the criminal court, of course, is beyond a reasonable doubt. In dependency court, for most cases, it's a preponderance of the evidence. And when you have very young child victims, the DA's office is not going to want to
put them on the stand.
Right, and do a jury trial. And if particularly I think if the dependency court's involved, they'll just back off and they'll let us handle it.
Then, once you're done, do they then press charges on the?
No, usually not.
Do they take the statement if someone admits to doing something? Do they use that against them in the criminal court?
No, I've never seen that happen. I have seen cases where I've dismissed a case and then they've tried to file it in criminal court and it's been dismissed.
So if it didn't hit your level of preponderance of evidence, chances are it's obviously not going to hit the higher level
Right.
of beyond a reasonable doubt. What's been some of the most interesting cases you've seen, either as an attorney or a judge, that you've seen in dependency court?
Well, when I was an attorney, I had several what they used to call Munchausen by proxy syndrome cases, and those were pretty interesting.
Is that the one where they try to hurt the child and they try to save him and get the attention?
Yeah, it's basically where it's usually a mother tries to induce an illness in the child so that they can take the child to the doctor, or usually the emergency room, and basically present as a concerned, knowledgeable caretaker and receive a lot of praise from the hospital staff. And oftentimes it's very hard to detect because these mothers will go to numerous different emergency rooms. I used to have several feet of medical records on these cases because they had gone to so many emergency rooms with the same complaint over a period of years.
See very many of those anymore? Has that kind of died out?
I think it's kind of died out. I haven't been in Monterey Park for the last 2 years. I had one just before I became a referee. I've not seen any up here in the Antelope Valley. But I know that there's been a lot of discussion about whether or not it's a legitimate syndrome or not.
When that happens, do you then terminate the relationship when they go on the adoption track, or you still try reunification?
Actually, the 2 cases that I was involved, one we did reunify the child with the mother. The other one, it looked pretty much like we were going to. We transferred it to another county. But it looked pretty promising.
Sounds like you're trying to keep the family unit as much as possible, which is a different picture than a lot of people may get of dependency court, where the family gets temporarily, they feel torn apart. You're trying to you're trying to solve the problem and put everybody back together.
Right, but I try to do it in a way that's safe for the children and a way the parents aren't going to fail, because a lot of these problems are something that's an intergenerational problem. These parents have not been parented very well by their own parents, and they don't know how to do it. And so you have to look at the big picture, and that's kind of what I'm interested in. And so what I try to do is make sure that they've got the support, gradually liberalize the visits so that they have more contact with their children while they have the support, and then return the children gradually, because I think you have a much better chance of it becoming a permanent home of parent order then.
We've got a call. This is Attorney Steve Fox with Her Honor Valerie Skeba. Can we help you?
Yes, I had noticed earlier you had mentioned something about if there were a group of siblings and one were under the age of 3, that gave the parent 6 months to reunify. I had been told that if a child was 2 or under the age of 2, that the parent only got 6 months to reunify. Is that correct?
No, it's 3 or under. So it's under 3. So if they're under 3, it's 6 months unless I can make the finding that they're in compliance and they're making substantive progress.
Okay, great. Thank you very much.
You're welcome.
And again, if you have a question, and we're very lucky tonight to have Her Honor here, give a call at 726-0382. For one, I'm learning quite a bit.
Oh, there's something I should bring up, which I think is very important to people in the Antelope Valley, and that is the Indian Child Welfare Act. Because if a parent is an enrolled member of a federally recognized tribe, Indian tribe, the federal law, the Indian Child Welfare Act, applies to those parents. And for one thing, it raises the standard of proof significantly.
To take away the child.
Right.
So you have to prove more. And I've noticed that there's sections like that also on family law as well, when we're dealing with that. And it rarely comes up, but it's interesting. So you're saying that if it turns out, what percentage Indian does the person have to be?
It depends on the tribe. The tribe's the one who makes the decision. So some tribes, they go by whether it's a matrilineal tracing, I guess you'd call it, where the person of Indian origin has to be on the maternal side. Some tribes it's the paternal side. And each tribe determines what percentage of Indian blood they want. Now, I just had one tribe that I have a kid in one of the cases. These kids are covered under the Indian Child Welfare Act, and then the tribe raised the quantum of Indian blood required so that the 2 younger children don't qualify anymore. So,
interesting.
but the requirement is that the parent needs to be enrolled, the biological parent needs to be enrolled, and the children need to be eligible. So just because a parent is enrolled doesn't mean their child is going to be eligible. But it's a very significant help.
By enrolled, what do you mean?
They're on the
tribes list?
They're on the tribal roll. Now, some parents who aren't enrolled can become enrolled. I've had parents do that. And then the Indian Child Welfare Act applies to them. And it's particularly for fathers, it's very important because it recognizes biological father, not presumed father or alleged father, or any of those variances. So that's something, if people come into court and they have their enrollment certificate, I can apply that Indian Child Welfare Act at detention, and they have a much better chance of either that child being placed with a relative right away or going home with their child than if they don't have that information. So that's something people should really try to do.
And have you seen a number of different tribes in the last 2 years? Do we have a reasonable Indian population out here? Or?
I've been told we have a pretty high one. I've had a number of tribes, the Potawatomi tribe, the Hopi tribe. We've had Seminole tribe. We have a lot of people who claim Blackfoot heritage, but so far nobody's really qualified under that tribe. But there are a significant number of Indian people of Indian descent, and my feeling is that if people had more information, they would probably qualify. But we just don't, they can't usually get that information in a quick amount of time.
Now, right now the standards of preponderance of evidence for things to happen. What does the standard change if they are under an Indian heritage?
It becomes clear and convincing. And that applies to detention as well. So I have to find by clear and convincing evidence that there's a substantial risk of detriment. And oftentimes the department just is not able to meet that standard at a detention hearing unless the child has visible injuries or there's serious substance abuse. A lot of times they just don't have enough information. So it's something that makes a huge difference. The Indian Child Welfare Act also requires placement with relatives, and if not relatives, in an Indian home. Now that can be a problem because there aren't many Indian homes in the Antelope Valley.
So it doesn't even have to be a relative. We go to an Indian home before we go to a foster home.
Right, but oftentimes they still wind up in foster homes because we don't have very many Indian homes in the Antelope Valley that qualify. But it does help placement with relatives. The family's also entitled to more services, a higher standard of services. So it's a significant benefit to the families if it can apply, and the children well.
What's the length of time the average process takes when something's in dependency court? 6 months, 9 months, a year? What's the norm, if there is such a thing?
Well, usually if you're talking about a child from detention to being returned, not being returned to their parents, but being terminated in their parents' home and the case is terminated, it's usually about a year.
So someone can actually be in the dependency court process for a year-long period.
Right. If they're doing everything really well, it could be terminated sooner. But a lot of times people have trouble just getting started. They've usually had this tremendous trauma in the family. Sometimes they just can't really get themselves together for a few months, and it takes a little bit longer. And sometimes they have serious financial problems. They need to get working. There are all kinds of problems that a parent has because if their children are taken away, they will lose AFDC, or what's now called TANF. They can lose their Section 8 housing. So all these things can cause major setbacks.
So if they temporarily lose the child, then they lose their Section 8, so they have no
Right.
home. They lose their AFDC, so they have no food stamps and no money. So when they get the kid back, it's going to take a period of time to requalify, if at all. Section 8, I think, takes a long time to even get this set up. So that would make it harder then, is what
Right.
you're saying?
Right.
To be able to show that, yes, they have a home where the child can come back in.
That's right. Although the department has programs that will help them. Family preservation is one. Family preservation will sometimes be in a position to provide them with first and last on an apartment, or it can help them get into Section 8. They will go out and buy furniture and food and clothes for the family.
So I, as an attorney, walk in, I realize my client has lost all these county benefits. I can make a motion to request additional assistance then if the court grants it, for the county to pay, as you said, first and last. So that is what is the level of finding to get that?
No, what you do is you request family preservation. And family preservation will look at the family, decide whether or not they can help this family. And they can provide intensive counseling, they can provide various services. Sometimes parents, like I said earlier, need to learn how to parent. And so they'll send a home aide to come out to the home and help that parent, give them advice how to deal with this child. Actually sit there with them and help them learn how to bond with their child. So you usually request family preservation. Oftentimes there is a waiting list, so we try to do it early. If we think that the family could benefit, we try to get it in early.
Get them on the list.
Right.
And with that, we have to go to a break. And again, make sure when you call back, 726-0382. Thank you. Welcome back to the Steve Fox Show, where it's you and the law. But instead of just two attorneys tonight, we're very honored. We have Judge Skeba on with us tonight, who's in charge of the dependency court, who's been our dependency judge for the last 2 years. I've had the honor to appear in front of. And before we cut to break, we were again saying that if anybody would like to ask a question on dependency, they can call it 726-0382. That's 726-0382. And before we were discussing the length of time it takes for reunification, and you were telling me also the services that can be rendered. It's interesting. It seems to take a long time to some of us who are standing from the outside, but I guess depending on the situation, it can take a long or a short time.
Right. I've had a number of cases that will terminate with, well, I have options that when I do a disposition, which is similar to sentencing, with some cases I think the family really doesn't need to be in the system for all that long. Sometimes I can avoid declaring the child a dependent and just sort of putting the case, monitoring it for anywhere from a couple of months to 6 months, and then terminate the case. Or I can do it for a less amount of time. And sometimes I will dismiss a petition if I don't
feel it's insufficient.
If there's insufficient evidence. Sometimes I'll return a child at disposition if I don't feel there's enough detriment, and the department will supervise them in the home of their parent. So most of the cases that take longer are the ones where there are really some issues that need to be addressed, like substance abuse or domestic violence.
If one parent's bad, done something inappropriate, and one hasn't, do you find that you really can't return the child sometimes because of the negligent parent?
It depends.
What do you do?
It depends on the parent. If there's a case where there's been an ongoing problem, such as domestic violence, then I probably wouldn't return the child because domestic violence is so damaging, and if it's been going on for some period of time and usually it's the mother hasn't tried to get out of the situation, then I probably would keep the child detained. If it's a sexual abuse case, sometimes the mother will have been told about it but has not come forward to the authorities. I may or may not order the person out and release to the parent, depending on a lot of times how the child feels about this parent not doing anything. Or sometimes there are extenuating circumstances, and I don't feel that the non-offending parent is really a risk. So it just depends on the...
A lot of times I've noticed when I take parents in, they'll ask them to sign certain language and recognize that. What's the purpose of the language, and can the language they sign end up terminating their parental rights?
Well, the purpose of the language is to really sort out what actually did happen. And so, and it's usually trying to reach a compromise where a parent will acknowledge that they did something wrong and, then go forward with addressing what the problem is. I don't feel that it's necessary to put in a whole lot of detail, like how many black eyes there were. I just really want to see that they've acknowledged, some wrongdoing. Ultimately, yes, if they submit or agree or admit that language and they don't address the problem, yes, their parental rights could be terminated, but they're not going to be terminated just because of the language. It's going to be whether or not they complied with the case plan. That's really the issue. I don't focus so much on the language. I want to know what has been done. What has the parent done?
So they acknowledge the wrongdoing, given a list of things to do.
Right.
Then they have to return again.
And then we monitor them. And sometimes I'll monitor them really closely, like every month or so, because sometimes the parents need to have somebody reminding them they have to do this, or they need praise, or they need somebody to, push them along. So it just depends on the parent, the family, how they're working with the social worker. If they look like they're going to do everything, I may not see them for 6 months. If they look like they need a lot of help and a lot of encouragement, then I may bring them back every couple of months. It just depends on the situation.
So you kind of tailor make the process to fit the individual and fit the situation.
If it's a child under 3 and they have only those 6 months, I'll keep a close eye on them, because sometimes they need somebody reminding them, hey, you've only got a couple of months left. You need to get going. So those families with young children that are really at risk of losing their kids, those ones I'll watch pretty carefully.
I really didn't, realize how much went into it, other than my job was always, when I go into a dependency court, to try to get the child back for the parents. And I've even advised the parent I represent that the other one should move out of the home, that they have a better chance of getting the child back in the home if the alleged perpetrator is out of the home. Is that also recommendable?
I think that's a good plan because of the very short time span you have for reunification. I think if one parent has a child and then the other person can work the case plan at their own speed, that's oftentimes better.
Yeah, we have a call again. It's Attorney Steve Fox with Her Honor Judge Skeba. Can we help you?
Hey Steve, it's Deanna. I told you I'd call.
Well, hello Deanna, how are you?
Good, thanks. I've got a question for the judge. You say that some foster families actually want to adopt the children if reunification fails. What kind of percentage of foster parents actually want to do this?
I don't know for sure. I think some foster parents are being foster parents solely for that purpose. They want to adopt a child, and they think the easier or the fastest way or the best way is to become a foster parent. Sometimes they just want to take in a child that doesn't have a home, or sometimes they think that it's easier than doing it privately. There are also some foster parents who have been doing it for years and they just like having children in their home. But I would say a pretty high percentage are doing it to adopt children.
I wouldn't have thought it was a high percentage. Thank you, that was interesting.
But don't they lose the money that they get as a foster parent if they do the adoption?
No, the federal government pays them what's called adoptive assistance until the child's 18. That includes Medi-Cal and usually whatever, $300 or $400 a month for that child.
So is it approximately the same money they get under foster care?
It's pretty close.
Except that they won't lose the foster kid. I mean, they lose the foster kid, but they won't lose an adopted kid, obviously, because it's theirs. So it's a safer bet they get to keep the kid if they get it adopted.
Right. Right.
That's interesting. Well, Deanna, any other further questions?
No, that was really interesting. Thanks for clarifying.
Thanks, Deanna. And that was always a question of mine. Now, is the dependency court can do adoptions as opposed to going into the separate adoption court, is that correct? Because I've gone in front of Judge Abenspoker and done adoptions, but I've also noticed adoptions through your court as well. Is it a slower or quicker process to go through your court as opposed to a regular adoption?
That I can't really tell you. I know that there's been a huge backlog. I mean, things have been backlogged for years. Adoptions have been waiting. Now we have a program where 2 or 3 times a year they open the court in Monterey Park, and we've done it up here once. And we do, in Monterey Park, they'll do 300 or 400 adoptions a day.
Jeez.
Up here, I think we did something like 50 or 60. And we'll just go through and do all the adoptions that are backlogged. And we've done a significant number. We've moved them along. So it's faster than it used to be. But compared to a private adoption, I really don't know. I would guess it'd probably take longer because of all the proceedings that you have to go through. There's so many stages to get to that point. And then even after parental rights are terminated, they still have more things that need to be done, the department has to do. So I'm guessing longer.
Well, I noticed in a regular adoption, you pay a certain fee, the county comes in, evaluates the adopted parent's house. I would suppose you wouldn't have to do that in your court because the county's already been
Right.
involved and they've already gone into the home and examined everything.
Right. It actually doesn't usually cost the foster parents anything because the attorney's provided. We tend to think that they're doing us a favor by providing a home for this child, so I don't. Sometimes they will hire a private attorney if they're really concerned about a parent trying to get the child back, but most of them don't, and so it really doesn't cost a foster parent that I know of, and maybe somebody would dispute this, but it doesn't cost them anything to actually do the procedure.
So basically you do reunification, adoption. Are there any other things within your court, or that's the basic purview of it?
Well, we have a procedure where a parent who's had their reunification services terminated can file a petition, which is like the OSC in family law, where they can allege that there's a substantial change of circumstance and it's in the best interest of the child to grant the modification, which is usually further reunification services to the parent or return of the child. And so that happens on a fairly regular basis.
So you're saying that if the child's been put in foster home and you feel the parent feels they've done enough to get the child back, and it looks like the process may take a year, the parent can file the, as we call it, the order to show cause, OSC motion.
Recall the 388.
Recall the 388 and have a redetermination on whether to take the child out of the foster home and give them back their child?
Well, usually when I do it, I don't usually just take a child from a foster home and put it back with the parent. If it really looks like it's a legitimate request, I'll grant a period of more reunification and then work from
More
there.
visitations?
More visitation.
So it's a gradual
right,
thing?
Right.
Now, do you ever do very much monitored visitations as opposed to just regular visitations?
We do mostly monitored visitation unless somebody has not, is a totally non-offending parent. Or sometimes we have parents who lose custody of their child temporarily, but they're really, there are other circumstances. Maybe the child is out of control, it's not the parent. Then we'll have unmonitored visits, but oftentimes initially we will start with monitored visits.
And who supplies the monitor and pays for the monitor?
Well, if they're with a relative, I will usually allow the relative to do it because I think it's better for the parent and better for the child. But if there is no relative available, then sometimes a friend can be approved as a monitor. Sometimes it could be a therapist. Oftentimes the foster family agency will provide a monitor, but it's usually in a small room, and I don't think it's that much of a good environment for visits, so I try to get them out of that environment and back into a more normal situation like a family home or going to the mall or something like that.
So I know in the family law court, the monitors that they recommend usually charge around $25 an hour. It becomes cost prohibitive for a lot of the monitoring situations.
We don't usually, most of the monitors are either the social worker, the FFA, or relatives. I rarely have somebody, a professional monitor, only in a few cases, and that was where a parent was relatively well off and could afford it. But there's also a center in North Hollywood that will do visitation on the weekend for working parents, but that's got a long waiting list. We do have a few people up here in the Antelope Valley who work for the department who are willing to monitor on the weekend, so I use those resources.
And it wouldn't hurt for us to, and I'll eventually ask you for that list of those people that do on the weekends to see if they want to also do it perhaps in our family law court as well, which is kind of interesting. Because again, we always have a shortage of monitors, at least, and the reason I say that is because I'm obviously in the family law court more than I'm in your court. Although I've been very happy to be in your court, I have to add, and it's been very professional. It's been a learning experience as well. Do you have any recommendations before we go off the air on somebody who all of a sudden has their child taken away from them, and again, if one child's taken away, I believe the others in the house can also be taken away.
Yeah.
What any recommendations you might give them before they're about to enter the process of the dependency court?
Well, as I said earlier, if you have Indian heritage, it's helpful to have that information right away. I would say it's helpful to have an information about relatives for possible placements. The sooner you can get that information to us, the sooner we can start that process, and that means people's names, dates of birth, addresses, social security, driver's license, and whether or not they're really available. So you need to talk to them and make sure that they are willing to do this, to care for the children or be a monitor. That's the sooner we can get the child with a relative, I think the better off everybody is, because the visits can occur there. Oftentimes the visits are more frequent. It's a better atmosphere for the child and everybody. If you can't find somebody who's going to be a relative placement, then a friend or somebody who can be a monitor, and these all have to be people without criminal backgrounds. So that kind of information is a good start. Also, if people if there are allegations of substance abuse and they've been going to programs, bring that information in.
Now, when someone looks to have someone else as a monitor, do they have to go through an approval process?
Right.
What does that process include?
Well, they usually have to be fingerprinted, and that can take a while because if anybody has been fingerprinted, there's a hold, and that means like somebody like yourself who was fingerprinted when they took the bar. We're not going to get your results back right away.
Or the different times I took the bar, each time was fingerprinted.
Right. So that's a little bit of a problem, but we're working to address that. They're going to want to speak with that person and make sure they understand what the rules are and if that person can follow the rules, because your best friend may not be the greatest monitor for you, because maybe they're going to have a hard time telling you that you've got to knock it off, and that's what the department wants to know. Are these people going to be able to enforce the rules? Because when they're monitoring, they can't be your best friend anymore. So
they're there to do their job, not to be their friend. Just like a school teacher, I was there to teach, not be the children's best friend.
Right, exactly. So those kinds of things are very helpful when you come into court. And the other thing, if you have family members that can come in, that's helpful too, although sometimes we get overwhelmed with the number of family members we have. But if I can get a look at all the family members and sometimes ask them questions, I can make decisions better than if I'm just left with guessing.
Paper and guessing.
Yeah, so sometimes having one or two family members, not 8, is really helpful.
So if we narrow down the information, you have a better chance of getting to the point. Well, how long does the process take for a monitor to get approved?
Well, again, it depends on a couple of things. One is whether the person has a criminal background. Unfortunately, there's oftentimes a transition period, because the person who goes out and detains the child will not ultimately be the social worker on the case. So there is a lag time for it getting approved or getting to the correct social worker. So that may slow the process down. It can take anywhere from a few days to several weeks. And what people need to do is keep in contact with their lawyers, because oftentimes I will order that the maternal aunt or the maternal grandmother be evaluated as monitor, and then I won't hear anything again. And then 6 weeks later I come back and I find out there's no information. And so 6 weeks have been lost.
With that, I want to thank you very much for being on our show. It was excellent. It was very educational for me, and I really appreciate it.
Well, thank you very much. I enjoyed it.
I appreciate that. I'd like to thank the audience, and stay tuned next week for You and the Law. Nice seeing you all.